A very, very good evening to all of you, friends. A very, very good evening to all of you. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. So, friends, today we begin with the weekly legal current affairs for the month of January, part 6, in which we shall be discussing about certain very, very important legal development that has taken place in India. Now, why are these sessions so important? Now, these sessions are important owing to the fact that insofar as your preparation for CLAT, ALIT, and other law entrance examinations are concerned, the kind of questions or the kind of passages that you find in your CLAT examination, they are based on certain important legal development that has taken place in the previous 1 year. Is that clear? So it is based on certain very important legal development, or rather we can say that the passages are based on what has happened, legal developments that have taken place in the last 1 year. So a very, very warm welcome to this very important session on weekly legal current affairs. So guys, let's begin. In this session, we are going to discuss three important legal development. Number one, no one can be penalized for holding an opinion not in conformity with constitutional values. That is what the Supreme Court says. So if you hold an opinion not in consonance with our constitutional values, even then you cannot be penalized for it. Number one. Number two, widowed daughter-in-law is eligible to compassionate appointment. We'll understand that. And the third one relates to the Haldwani eviction case. Sure, most of you have read it. There was a lot of hue and cry in the media also. And finally, the Supreme Court has stayed the Uttarakhand High Court's judgment or the order directing the Haldwani eviction. So these are the three important legal development that we shall be discussing in the course of this session. But before we begin, BYJU'S Exam Prep brings to you a free workshop on how to get a NLU call in CLAT 2024. This free workshop will be held on 29th of January at 7 p.m. by Abhimanyu Sir. So definitely register now so that there are limited seats available for joining the free workshop by Abhimanyu Sir. The first one, the Supreme Court in Kushal Kishore versus State of Uttar Pradesh opined that if an individual is holding an opinion, now we have freedom of expression, we have freedom of speech. Now, if an individual is holding an opinion which does not come in the line of our constitutional values, can he be punished? The Supreme Court simply says no. You cannot be penalized, you cannot be punished for holding an opinion which is not in conformity with the constitutional values. The Supreme Court says that an action of tort will lie only when opinion gets translated into action. Now, suppose there is a hate speech And as a result of that hate speech, there is a, a riot. Yes, you can be held responsible. But if you say tomorrow that, I do not believe in the principle of socialism, I do not believe in the principle of democracy. Fair thought, that is your opinion. And you are absolutely justified to hold any opinion. But the Supreme Court says there is a Lakshman Rekha, and that Rekha is the moment your words are translated into action. Suppose there is a fight, you will be held responsible. So a constitution bench held that a person cannot be penalized for holding an opinion opposed to constitutional values. Now, there were 5 judges. Justice B.V. Nagaratna dissented. But the Supreme Court judgment, the majority judgment, simply says this. One of the issues considered by the bench was, now this is very, very important. The question before the court was whether a statement by a minister inconsistent with the rights of citizen under Part 3 of the Constitution constitutes a violation of such constitutional right and is actionable in constitutional tort. So the question before the court was this, that whether a person, suppose a minister has given a statement which is opposed to our constitutional values, can he be prosecuted? Now, what did the court say? A statement made by a minister, either inside or outside the house, that is the parliament, or the state legislature of a state. A statement may also be made by a minister in writing or by words or spoken. A statement may be made in private or in public. A statement may also be made by the minister either touching upon the affairs of a ministry, department in which he is in control, or touching generally upon the politics of the government. A minister may also make statement in the form of an opinion, matters about his or her department in which he is holding power. So, it is absolutely necessary for us to right now understand this important, that a minister can make a speech inside the house, outside the house, in private, in public, relating to his ministry in which he is having some power, or general politics. So, he can make statement. He can also make statement about certain department in which he has no control. All such statements need not necessarily give rise to an action of tort or constitutional tort. That is what 4 judges, Justice Abdul Nazir, Justice B.R. Gawai, Justice A.S. Bopanna, and Justice V. Rama Subramanian, these were the 4 judges who said that such a statement made by a legislator, by a minister, does not give rise to an action of tort unless and until his words have translated into some kind of an action. Take for instance a case where a minister makes a statement that women are unfit to be employed in a particular avocation. It may reflect his insensitivity to gender equality and also may expose his low constitutional morality. The fact that due to his insensitivity or lack of understanding or low constitutional morality, he speaks a language that he has potentially to demean the constitutional right of women. It cannot be a ground for an action in constitutional tort. Needless to say that no one can either be taxed or penalized for holding an opinion which is not in conformity with constitutional values. Very important. So if you are holding, whether you are a minister or a citizen, if you are holding an opinion, for example, you do not believe in socialism. The preamble says, the constitution says, India is a socialist country. Even if you do not hold an opinion, you do not believe in gender equality. Fair thought. But that will not give rise to an action against you under the law. His opinion gets translated. Now, if his opinion gets translated into action, such action results in injury or harm or loss, that an action will lie. With the caveat, let us now get into the core of the issue. So the core of the issue is simply this, that the moment you say something and that statement is translated into some injury, there is some rioting, there is some fighting, there is a loss of property, there is a loss of human life, that will entail some legal consequences. The court held that a tort is a civil wrong that causes a claimant to suffer loss or harm resulting in legal liability for the person who commits the tortious act. So, unless your rights are violated, you cannot just say, somebody said something about something, I believe something, I don't agree, I will file a case for tort. No, that cannot happen. You have a freedom of speech. Now, that cannot be curtailed under by any such rule, right? A mere statement by a minister, very, very important. Now, you might get such kind of passages in your CLAT, and that's why we need to understand what the judge has said. A mere statement made by a minister inconsistent with the rights of citizen under Part 3 of the Constitution, fundamental rights, may not constitute violation of constitutional right and become actionable as constitutional tort. But if as a consequence of such a statement, any action or omission or commission is done by the officer resulting in harm or loss to a person or citizen, then some may be actionable as constitutional tort. Is that clear? Have I made myself abundantly clear to each and every one of you? Have I made myself abundantly clear? Okay. So guys, if you are watching today's session, please understand this. So you have Suresh Kumar who says, I'm starting my preparation from today. Do I have enough time? Absolutely, you have enough time. Don't worry. Provided you are properly, आप proper तरीके से पढ़ाई लिखाई कर रहे हो, ठीक है? Now let's see the dissenting judge, the judge who gave an opinion opposed to the 4 judges. A proper legal framework is necessary to define the acts or omission which would amount to constitutional tort and the manner in which the same would be redressed and remedied on the basis of judicial precedent. Particularly, it is not prudent to treat all cases where a statement is made by a public functionary resulting in harm or loss to a citizen a constitutional tort, except in the context of the answer given to question number 4 above. Now, what was the question number 4? A statement made by a minister. Now, Justice Nagaratna is of the view that, a public making a statement like you and me makes no difference. But if it comes from a minister, it makes a difference. Now, she is of that particular opinion. A statement made by a minister, if traceable to any affairs of the state, or for protecting the government can be attributed vicariously to the government by invoking the principle of collective responsibility, so long as the statement represents the view of the government also. If such a statement is not consistent with the views of the government, then it is attributable to the minister personally. Now, if the minister is saying something which the government believes, then the government can be held responsible. But if the minister is saying something which the government does not believe, then minister will be personally held liable. That is what Justice Nagaratna simply says. Okay, did you understand the first important legal development? Did you all understand? Great. So guys, BYJU'S Exam Prep brings to you a free workshop on how to get an NLU call in CLAT 2024. It will be conducted by Abhimanyu Sir on 29th of January at 7 p.m. Okay, all of you. Okay, fantastic, great. A BYJU'S Exam Prep also brings to you a comprehensive course for CLAT 2024. It will provide you 300 recorded videos across 5 sections, 300 plus hours of live classes, 35 mocks for CLAT and other law entrance examination, monthly e-magazine for current affairs, and the entire content is based on the extensive analysis of the last 5 years of CLAT. The next important legal development. Widowed daughter-in-law is eligible to compassionate appointment as a dependent. Now, let's understand the meaning of compassionate appointment. Now, suppose a bread earner or a breadwinner of a family dies, then there is a financial trouble in the family. Now, to overcome that, there is this concept of compassionate appointment, wherein an eligible person from the family will be given the job so that the family survives. Now, the question is, can a widowed daughter-in-law, a daughter-in-law who is widowed, is eligible for compassionate appointment? Now, what are the facts of the case? The mother-in-law was appointed in the post of a coolie. She died while working in harness, and an application for compassionate appointment was filed by the petitioner's husband, who also died, leaving the petitioner widowed. So the mother died, she was working, the son applied for compassionate appointment. During the proceeding, the son also dies. The son's wife, the daughter-in-law, applies. She has 3 minor children. Being an uneducated lady, with no alternative sources of employment, petitioner made an application for compassionate appointment. However, she was declined compassionate appointment on the ground that she was the daughter-in-law. It does not fall within the term dependent under the Rajasthan rules. Now, the Rajasthan High Court held that widowed daughter-in-law is eligible to compassionate appointment as a dependent under the Rajasthan Compassionate Appointment Dependent and Deceased Government Rules 1996. So, the Rajasthan High Court says that even the daughter-in-law is eligible under the 1996 rules to get compassionate appointment. Am I clear? What did the judge say? In this regard, it would be prudent to say that the judgment relied upon by the counsel for the petitioner in the case of Pinky vs. State of Rajasthan, which was upheld by the division bench of the Rajasthan High Court, is squarely applicable to the facts of the present case. In the said judgment, it was held that certain rules of the 1996 rules, we must interpret a widowed daughter who is expressly included in the mandate of the said rules to mean a widowed daughter-in-law as well. meaning thereby a widowed daughter-in-law shall also be covered under Rule 2C, that is dependent. It was further held that as per the customs of the Indian society, daughter-in-law is also supposed to be treated as a daughter, and she is an integral member of the family who possess all honor, responsibility of the household. So that is what Justice Samir Jain of the Rajasthan High Court had to say about this particular factual situation, whether a daughter-in-law is eligible for compassionate appointment. Am I clear? Am I clear to each and every one of you? Thus, the bench noted the rules of 1996 are beneficial and therefore must be interpreted harmoniously to read that a daughter-in-law who is a widowed daughter-in-law is a part and parcel of a widowed daughter, and hence compassionate appointment will be provided to her. Is that clear? All of you? Is that clear to each and every one? Am I clear to each and every one of you? Any doubts? Okay. So guys, if you are liking this session, do press the like button and share this session with people who are preparing for CLAT 2024. BYJU'S Exam Prep congratulates Anika Sahgal for securing AIR 18 in ALET 2023. The third important development, the Supreme Court of India has stayed the Uttarakhand High Court's direction for Haldwani eviction. Now, I'm sure that you guys are aware of Haldwani evictions. Now, the Uttarakhand High Court had ordered certain occupants residing in and around the railway land to be evicted. Now, based on the Uttarakhand High Court's order, authorities, the government, issued notices to the families for eviction. These families who were given the notice, they claim that they have been residing in this area for many, many years and they have valid documents under the government authorities. The High Court directed the removal of the occupants in 7 days. Now, 7 days. Now, there are around 50,000 people who are residing in those areas. Now, if the High Court is saying remove everyone, remove 50,000 people in this cold winter in just 7 days, now, to my mind, it is a little unreasonable order. Now, these people might be holding the lands of the government. I don't doubt. Some people claim that, they have government pattas, they have government documents, valid documents from the government stating that they are the owner of the land. But be that as it may, we are not getting into that. Now, giving a 7-day notice, providing a 7-day notice for the removal of approximately 50,000 people is very unjustified. The Supreme Court said that there cannot be uprooting of 50,000 people in 7 days. If the government wants to uproot people, there should be a phase-wise manner. Okay, there has to be a procedure. The bench further noted that the state of Uttarakhand and the railways were dealing with the special leave petition filed against the judgment. The matter has been posted on February 7, 2023, and the court has asked the state and the railways to find a practical solution. Now, it is very, very important. Now, the government requires the land, and you see there are so many people who are dwelling upon that land. Fair thought. There are a number of people who are in the land. But there needs to be a practical solution to this problem. You cannot tomorrow say, 50,000 people, you are in my land, in a cold night, in a cold winter night, I'm going to make you homeless. Now, these poor people have been staying in the property, in that land for years after years. Now, providing them with just a 7-day and asking them to be removed, to my mind, is a little unjustified. And that's the reason why the Supreme Court gave this stay order, has stopped the enforcement of the Uttarakhand High Court order directing eviction of those 50,000 people on the railway land. What did the judge say? The Supreme Court. There are two aspects of the issue. One, they claim lease. Two, they say that people migrated after 1947 and the lands were auctioned. People stayed there for so many years. Some rehabilitation has to be given. There are establishments here. How can you say in 7 days clear them off? Now, there are schools, there are government schools, business enterprises in that area. So there are shops, there are houses, there are schools of the government. Now, overnight, can you ask authorities to remove and clear the entire piece of land? Is that clear to everyone? So here is a particular case wherein we see a kind of insensitivity on the part of the High Court. Why? Number one, because giving 7 days is not enough. At least 6 months. Now, overnight, where will these poor 50,000 people go? And henceforth, the Supreme Court is of the view that a practical solution has to come from the government and the railways insofar as rehabilitating these 50,000 people are concerned. Is that clear? People say they have been there for 50 years. What is troubling us is that how do you deal with a scenario of people who have purchased the land in auction? You may acquire the land, you require the land, you want the land, I all understand. But these people have been staying there for 50, 60 years. Some rehabilitation scheme has to be done. Even assuming it is a railway land, there is a human angle to it. That is what Justice Sanjay Kishan Kaul of the Supreme Court said during the hearing while staying the Uttarakhand High Court judgment relating to eviction of Haldwani railway land. Now, Justice Oak was of the view that the High Court had passed the order without hearing the affected party. So there were two judges, Justice Kaul and Justice Oak. Justice Oak says that the High Court has passed the order without hearing the parties. He further asked to find out some solution to the problem since it is a human issue. Supplementing the observation of Justice Oak, Justice Kaul added, the human issue arises for a long period of occupation. Maybe all of them cannot be painted with the same brush. Maybe there are different categories. But the individual cases have to be examined. Somebody has to verify these documents. So people over there, people who have been asked to leave the property, they say that they have been staying, they have valid documents. Now, there has to be somebody who has to verify these documents. Now, without verifying these documents, you cannot hold them that leave the land. And Justice Oak was of the view that the affected parties, those 50,000 people, were not being heard in the court. Now, this land dispute of Haldwani traces back to 1907 government records on the basis of which the Gafur Basti claims ownership of the land. So the history starts in 1907. People are residing in the land claims that these plots were purchased by their ancestors under the custodian department of the government of India. They also claim that these plots were given by the government land. These were part of the government land used for non-agricultural but public purpose. According to the statement of Jamaat Islami Hind, the disputed land is 29 acres where people are living for around 80 years. 79 acres have been served with eviction notice. Now, the disputed land is 29 acres, which this is what one of the parties says, but around 80 acres of land has been served the notice. The High Court held that the record was mere an office memorandum, and any translation of the land will now be deemed invalid by observing the following. Now, what did the High Court say? A railway line was laid down by the company in the year 1884, and it was later on transferred to the government of India in 1943. So this dispute, as I say, does not arises in just 4 or 5 years. It started in 100 years back, 120 years back. The High Court, in its order, authorized use of force to evict people. Now, that is something which even struck the Supreme Court. The High Court says police use force to evict these people. Now, several petitions were filed in the Supreme Court challenging the Uttarakhand High Court order, which would affect around 4,365 families and 78 acres of land. Now, there has been a stay order on this, so nothing to worry right now. But let's see what happens in the court. We will bring to you all the latest updates like we bring always. So guys, BYJU'S Exam Prep brings to you CLAT 2024 comprehensive course. Secure a seat in your dream NLU. We provide you in this course 300 plus recorded videos across 5 sections, 300 plus hours of live classes, 35 mock tests with CLAT and other law entrance examination with video solution, e-monthly magazine on current affairs, and the content is curated based on our analysis of the last 5 years. So guys, with this, we come to the end of this session. Do subscribe and press the bell icon. Do like this session. Do share this session with your friends on your networking sites. Do follow us on our Instagram. Do like our Facebook page. Do join our Telegram channel. And do not forget to download the BYJU'S Exam Prep app. With this, we come to the end of this session. Thank you very much. Have a great week ahead. Bye-bye. Take care and happy Republic Day in advance. Thank you. God bless you. All the best.